In this lecture, we shall discuss some 15 questions and answers on civil procedure in Ghana. 15 questions and answers, and they'll be related to pleadings as far as the civil procedure of Ghana is concerned. The first question is as follows: what are pleadings? What are pleadings? The answer is as follows. According to Order 82, Rule 3 of the CI 47, pleadings are the formal allegations by the parties to a lawsuit of their respective claims and defenses with the intended purpose of providing notice of what is to be expected at the trial. Again, according to Order 82, Rule 3 of the CI 47, pleadings are the formal allegations by the parties to a lawsuit of their respective claims and defenses with the intended purpose of providing notice of what is to be expected at the trial. According to Poku and Frimpong, the following processes are all pleadings: statement of claim, statement of defense, counterclaim, and reply. This is the end of the answer. Now, the critical point you should note about this answer is that pleadings are only the formal allegations of the parties. They are not the pieces of evidence. They are the allegations of both parties to a lawsuit. The purpose is to provide notice of what is to be expected at the trial, so that if in your pleading you have mentioned that the defendant has defamed you, then we know that in the course of the trial you are going to bring evidence to show that this person has defamed me. So that's why it says that it is the formal allegation of the parties with the intended purpose of providing notice of what is to be expected at the trial. According to Poku and Frimpong, the following processes are all pleadings: statement of claim, statement of defense, counterclaim, and reply. Also take note that a writ of summons is not a pleading. A writ of summons is not a pleading. An appearance is also not a pleading. The pleadings are only the formal allegations of facts. An appearance has no allegation of facts, so an appearance will not be a pleading. Next question reads as follows. Question 2. When is a defendant required to file a statement of defense? When is a defendant required to file a statement of defense? In other words, for you, the defendant, after you've been served with the writ of summons and statement of claim, what are the timelines you have to file your defense? The answer is as follows. According to Order 11, Rule 1, according to Order 11, Rule 2, Sub-Rule 1 of the CI 47, the defendant who files an appearance and intends to defend the action has within 14 days after the expiration of the time limited for filing appearance to file a statement of defense. According to Order 11, Rule 2, Sub-Rule 1 of the CI 47, the defendant who files an appearance and intends to defend the action has within 14 days after the expiration of the time limited for filing appearance to file a statement of defense. That is as far as the timeline for filing a statement of defense is concerned. The next question reads as follows. When is a plaintiff required to file a reply? When is a plaintiff required to file a reply? The answer is as follows. According to Order 11 Rule 3 of the CI 47, the plaintiff has within 7 days after service of the statement of defense to file a reply. According to Order 11 Rule 3 of the CI 47, the plaintiff has within 7 days after service of the statement of defense to file a reply. Critical points to take note of. It is 7 days not from the filing of the statement of defense. It's after the service. So when you be served with the statement of defense, that's when the 7 days will begin to run. So take note of the word service. The plaintiff has within 7 days after the service of the statement of defense having been served to file a reply. Next question reads as follows. Are there any other pleadings that the parties can file after the service of the reply? The import of this question is that you remember in Poco and Frimpong we mentioned that pleadings will include the statement of claim, statement of defense, counterclaim, and the reply. Are there any other pleadings that the parties can file after service of the reply? When you file your statement of claim, you file a defense, you file a reply. Are there any other pleadings that can follow thereafter? The answer is as follows. Yes, after the service of the reply, there are other subsequent pleadings which are rarely delivered, such as, in other words, after service of the reply, there are other pleadings, but they are rarely delivered, and they include 1. Rejoinder. The defendant, after the reply, can file a rejoinder. When the defendant files the rejoinder, the plaintiff can also file a surrejoinder. After the plaintiff has filed that, defendant can also file a rebutter, and plaintiff can also file a surrebutter. So, these are points as far as the service of pleadings after the reply are concerned. After the reply, you can file a rejoinder by the defendants. Plaintiff can file a surrejoinder. Defendants can file a rebutter. Plaintiff can file a surrebutter. But take note that after the reply, no subsequent pleading shall be filed except with leave of the court. It means that all these processes, rejoinder, surrejoinder, rebutter, surrebutter, before you file them, you must seek leave of the courts. So you add that according to Order 11 Rule 4 of the CI 47, no pleading subsequent to a reply shall be filed except with leave of the court. Then to question 5, reads as follows. When do pleadings in an action close? When do pleadings in an action close? The answer is as follows. According to Order 11 Rule 19 of the CI 47, pleadings in an action close under the following circumstances. According to Order 11 Rule 19, pleadings in an action close under the following circumstances. 1. If there is no reply, but only a statement of defense. Pleadings close 7 days after service of the statement of defense. If there is no reply, but only a statement of defense, pleadings close 7 days after the service of the statement of defense. So take note. It is 7 days after the service of the statement of defense. That's if there's no reply. What if there's a reply? If there is a reply, then pleadings close 7 days after service of the reply. So you've seen 2 instances. If there's no reply but only a statement of defense, pleadings close 7 days after service of the statement of defense. If there's a reply, pleadings close 7 days after service of the reply. What if there's no reply, but there's only a defense to counterclaim? If there's no reply, but only a defense to counterclaim, pleadings in an action close upon service of the defense to counterclaim. If there is no reply, but only a defense to counterclaim, pleadings in an action will close upon service of the defense to counterclaim. So these are the instances under which pleadings in an action will close. 3 instances. 1. If there is no reply, but only a statement of defense, pleadings close 7 days after service of the statement of defense. If the plaintiff files a reply, then pleadings will close 7 days after service of the reply. If there is no reply but only a defense to counterclaim, pleadings in an action will close upon service of the defense to counterclaim. The next question. Why is it important to know when pleadings in an action close? Why is it important to know when pleadings in an action close? The answer is as follows. Knowing when pleadings close is relevant for the following purposes. 1. It enables the parties to know whether they can amend their pleadings and writs with or without leave of the courts. This is because, according to Order 16 of the CI 47, a party is allowed to amend pleadings and or writs without leave of the court once before pleadings close. So it enables the parties to know whether they can amend their pleadings and writs with or without leave of the courts. This is because, according to Order 16 of the CI 47, a party is allowed to amend pleadings and or writs without leave of the courts once before pleadings close. It also enables the parties to know when they can apply for directions. This is because, according to Order 32 of the CI 47, the plaintiff is required to apply for directions within 1 month after pleadings in an action have closed. It enables the parties to know when they can apply for directions because, according to Order 32 of the CI 47, the plaintiff is required to apply for directions within 1 month after pleadings in an action have closed. So you need to know when pleadings have closed for these purposes. It will let you know whether you can amend your writs without leave or you must seek leave, because the rules say that you can amend your writs once without leave, once before pleadings close. It can also enable you to know when to apply for directions. This is because you apply for directions within 1 month after pleadings in an action have closed. The next question reads as follows. What is meant by the rule against departure? What is meant by the rule against departure? What is meant by the phrase, the rule against departure? The answer is as follows. According to Order 11 Rule 10 of the CI 47, a party will not be allowed in a subsequent pleading to make any allegation of fact which is inconsistent with the previous pleading. Critical words you must mention. A party will not be allowed in a subsequent pleading. So there must be an earlier pleading, and we are referring to the subsequent pleading. So a party will not be allowed in a subsequent pleading to make any allegation of fact which is inconsistent with the previous pleading. You must always make sure you mention a subsequent pleading and the previous pleading. So according to Order 11 Rule 10, a party will not be allowed in the subsequent pleading to make any allegation of fact which is inconsistent with a previous pleading. In Hammond and Odway, the plaintiff was, by his reply, setting up a case which was completely inconsistent with his former pleading without asking leave to amend the statement of claim. In other words, in this case, the plaintiff has advanced a case in the statement of claim. But in his reply, he was seeking to advance a case which was inconsistent with what was in the statement of claim. Because plaintiff has filed the statement of claim, defendant files his defense, and then in your reply as plaintiff, you are putting a fact there which is inconsistent with what you have in your statement of claim. The court held that the trial judge should have disregarded that part of the reply, which was at variance with the case put forward in the statement of claim. So the answer once again is, according to Order 11 Rule 10 of the CI 47, a party will not be allowed in the subsequent pleading to make any allegation of fact which is inconsistent with the previous pleading. In Hammond and Odway, the plaintiff was by his reply setting up a case which was completely inconsistent with his former pleading, without asking leave to amend the statement of claim. The court held that the trial judge should have disregarded that part of the reply which was at variance with the case put forward in the statement of claim. The next question, question 8, reads as follows. When a statement of defense is filed during the legal vacation, is the time for filing reply computed during the legal vacation? The meaning of this question is that lawyers embark on legal vacation in the Superior Court. The court will have a legal vacation in August and September. If you serve me with a statement of defense, do I have that the 7 days I have to file my reply, do we count that 7 days during the legal vacation? The answer is as follows. According to Order 80, Rule 2 of the CI 47, the times of vacations in any legal year are to be excluded for reckoning any period for serving, filing, or amending a pleading. According to Order 80, Rule 2 of CI 47, the times of vacations in any legal year are to be excluded for reckoning any period for serving, filing, or amending a pleading. Question 9 reads as follows. What options are available? What options must a defendant consider in preparing a statement of defense? What options must a defendant consider in preparing a statement of defense? If you are a defendant and you are preparing your statement of defense, what are the options that you must consider? The answer is as follows. In preparing a statement of defense, the defendant has the following options. 1. Defendants can either admit or deny. 2. There can be confession and avoidance. 3. There can also be a set-off. 4. Defendants can counterclaim. 5. Defendants can plead accord and satisfaction. Accord and satisfaction. 6. The defendants can also rely on the defense of tender before action. So 6 options among many other options. You can either admit or deny, confess and avoid, set off, counterclaim, accord and satisfaction, tender before action. So if you see a question, what options must a defendant consider in preparing a statement of defense? Remember these 6 options. Question 10. What is a counterclaim? What is a counterclaim? The answer is as follows. According to Order 12 of the High Court Civil Procedure Rules 2004 CI 47, when a defendant against whom an action has been brought has any cause of action against the plaintiff, according to Order 12 of the CI 47, when a defendant against whom an action has been brought has any cause of action against the plaintiff, the defendant may, instead of bringing a separate action against the plaintiff, counterclaim in that same suit against the plaintiff if the causes of action can be tried together. If after the counterclaim, the court considered that the causes of action cannot be tried together, the court will order separate trials. A counterclaim is therefore, in essence, a cross-action which is independent from the plaintiff's action. Therefore, when a plaintiff's action is struck out or withdrawn, the defendant may still proceed with the counterclaim. In essence, what this answer means is that if you're a defendant and the plaintiff has brought an action against you, and you think you also have an action against the plaintiff, rather than bringing a separate suit, you can counterclaim in that same suit. If after the counterclaim, the court realizes that looking at the nature of the two cases, they cannot be tried together, then the court can then order that the cases be tried separately. A counterclaim is therefore a cross-action which is independent of the plaintiff's action. Therefore, when the plaintiff's action is struck out or withdrawn, the defendant may still proceed with the counterclaim. Question 11. What is a set-off? The answer is as follows. Set-off is a defense available to a defendant against whom an action for the recovery of money has been commenced. Set-off is a defense available to a defendant against whom an action for the recovery of money has been commenced. The defendant can rely on the set-off to reduce or extinguish the monetary liability of the defendant to the plaintiff. The defendant can rely on a set-off to reduce or extinguish the monetary liability of the defendant to the plaintiff. Keywords: to reduce or to extinguish monetary liability. So 3 keywords must always feature in the answer. The defendants can rely on a set-off to either reduce or extinguish the monetary liability of the defendant to the plaintiff. A set-off remains a defense and not an independent action. A set-off remains a defense and not an independent action. And therefore, when the plaintiff's action is struck out or withdrawn, the defendant cannot proceed with the set-off. A set-off is only a defense, and therefore, if the plaintiff's action is struck out or withdrawn, the defendant cannot proceed with the set-off. The next question reads as follows. Question 12. What is the difference between a counterclaim and a set-off? What is the difference between a counterclaim and a set-off? The answer is as follows. A counterclaim is a cross-action which has an existence independent on its own, whereas a set-off remains a defense. A counterclaim is a cross-action which has an independent existence on its own, whereas a set-off remains a defense. Therefore, when the plaintiff withdraws his action, or the action is struck out, because the counterclaim has an independent existence, the defendant can proceed with the counterclaim against the plaintiff. However, when the defendant relies on a set-off, which is merely a defense, the plaintiff's action is struck out or discontinued, the set-off also collapses. So the first distinction is that a counterclaim is a cross-action which has an existence independent on its own, whereas a set-off remains a defense. Therefore, when the plaintiff withdraws his action or the action is struck out because the counterclaim has an independent existence, the defendant can still proceed with the counterclaim against the plaintiff. However, when the defendant relies on a set-off, which is merely a defense, when the plaintiff's action is struck out or discontinued, the set-off also collapses. This makes sense because the counterclaim is indeed a fresh action. So when the plaintiff withdraws his action, the counterclaim, which is a fresh action, we can still proceed with it. But set-off is only a defense. So the set-off draws its life from the writ before the court. So when the action is struck out, the set-off will also collapse. That's the first distinction. Second distinction. Set-off is used to reduce or extinguish the liability of the defendant to the plaintiff. Set-off is used as a defense to reduce or extinguish the liability of the defendant to the plaintiff in monetary claims against the defendant. However, a counterclaim can be in respect of any cause of action which is not related to a monetary claim. And this means that if you are going to rely on a set-off, you are going to rely on it to only reduce or extinguish liability when the claim against you is for the recovery of money. But as for counterclaim, you can counterclaim in relation to land, in relation to defamation, or anything at all. So the difference is that set-off is used as a defense to reduce or extinguish the liability of the defendant to the plaintiff in monetary claims against the defendant. However, a counterclaim can be in respect of any cause of action which is not related to a monetary claim. Third difference is that a set-off must only be against the plaintiff who is a party to the action. A set-off must only be against the plaintiff who is a party to the action. However, a counterclaim can be made against the plaintiff and other persons who are not even parties to the suit. So a set-off, because it's only a defense, it can only be against the plaintiff because it's only a defense. But because counterclaim is a fresh action, you can counterclaim against the plaintiff and other persons who are not even parties to the suit. Next question, question 13. Explain accord and satisfaction. Accord and satisfaction. The answer is as follows. This refers to a situation whereby parties to a former agreement have entered into a subsequent agreement in which they have agreed that the terms of the former agreement have been satisfied or performed. Parties to a former agreement have entered into a subsequent agreement in which they have agreed that the terms of the former agreement have been satisfied or performed. And let me explain this. We have a contract for me to deliver 500 vehicles to you. And you have paid 1 million cedis into my account for that particular transaction. I'm supposed to deliver 500 vehicles to you and you have paid 1 million cedis into my account. It means I'm bound to deliver the vehicles to you. But later on, we enter into another transaction where you ask me to pay that 1 million cedis that you've given to me to your account in the US for a gold transaction. So I transfer the money to your account in the US. Now you have sued me to deliver those 100 vehicles to you. What do I say? That I can show that even though we had a former agreement, which was to the effect that I had to deliver the vehicles to you, we entered into a subsequent agreement in which we all agreed that the terms of the former agreement have been satisfied or performed. And that's why I went ahead to pay the money to the other party. So accord and satisfaction. Next question, question 14. Explain confession and avoidance. Confession and avoidance. The answer is as follows. This is a defense available to a defendant who admits the facts alleged by the plaintiff, but also proceeds to allege fresh facts which have the effect of neutralizing the effects of the allegations made by the plaintiff. For example, the defendant may end up admitting the claim of the plaintiff, but the defendant will proceed to allege that the claim of the plaintiff is statute barred or caught by limitation. So I would admit the case of the plaintiff, that I admit the claim, but I allege a fresh fact like limitation, which will have the effect of neutralizing the claim of the plaintiff. Then the next question, which is question 15. Can a defendant make a counterclaim against a person who is not a party to the suit? In other words, if a plaintiff has sued the defendant and the defendant is counterclaiming, can the defendant counterclaim against the plaintiff and add people who are not parties to the suit? The answer is yes. A defendant is allowed by Order 12, Rule 5 of the CI 47 to counterclaim against additional parties who are not originally parties to the suit. A defendant is allowed by Order 12, Rule 5 of the CI 47 to counterclaim against additional parties who are not originally parties to the suit. This is the end of the fifth set of questions for our revision on civil procedure. In our next lecture, we shall move on to the sixth set of questions, and those questions will also be on pleadings. Thank you.